Hello and welcome. This video is part of a series on ICPR's research finding on understanding and reducing the use of imprisonment. Today's conversation will focus on pretrial detention. Almost 4 million prisoners in the world are awaiting trial or conviction. That means about 1/3 of the overall prison population. The international standards and most legal systems state that pretrial detention should be an exceptional measure. However, in practice, it's widely overused. This has severe consequences for overcrowding, for poor prison conditions, but also for access to justice. Today, we have two experts with us to discuss the issue. Laure Baudrier-Gérard is a solicitor and a criminologist. She's Fair Trial's legal director, and she engages in legal and policy work in Europe and in strategic litigation. She also participates in prison monitoring in Brussels. Diana Ribaijiner is a Greens EFA member of European Parliament. She has a background in culture and she entered politics following the imprisonment of her partner for his political role during the Catalan referendum. She focuses, amongst many other issues, on the penitentiary system in Europe.
This is a really important discussion because pretrial detention is the harshest measure that a state can take against a person. It's about depriving a person of their liberty before any court of law has sentenced them, before any court of law has actually established their guilt. So it's about locking up in prison a person who is still presumed innocent at this stage, that is during the investigation. And it's generally based on assumptions that the person presents a risk. It could be a flight risk, a risk of evading justice, a risk of collusion, a risk of harm. And that risk is often assessed with very limited information at hand and often with very little time at hand as well. It's often carried out within minutes, literally a few minutes. A person's fate is sealed. And I say sealed because even a few days, a few weeks, a few years, because some member states don't even have a maximum duration limit on pretrial detention, can have a dramatic consequence on a person's life. It can mean a job loss, it can mean loss of your house, your apartment, it means separation from your family, from your children. It also means that when you're detained pretrial, you're more likely to be convicted, to enter a guilty plea because of the pressure of being in detention, to receive a jail sentence as well, or even a longer jail sentence that confirms the time that was spent in pretrial detention. And it also means, and I think it's really important to flag this as well, that it also means when you're putting someone in detention, you're also putting them in a place where they are at risk, where they are hugely vulnerable of physical harm. And I'd like to recall this statistic by the World Health Organization, that on average, 1/4 of prisoners are victimized by violence each year. That's huge. And incarceration itself is violent in the sense that the conditions in which people are incarcerated are brutal. Many of our jails today in Europe, including here in Belgium, where I do monitoring work, but also in France, in Romania, suffer from prison conditions that are so bad that detained people are subject to inhuman and degrading treatment, which is in violation to our country's obligations with international and regional human rights standards. And in half the member states, it's 1/4, 25% of prison population is made up of legally innocent people who are awaiting trial. And this is a huge number that's driving prison overcrowding, which in turn is making prison conditions deteriorate further and further.
Creo que cuando hablamos de prisión preventiva tenemos que tener tres cosas muy claras. Una es el número de presos que están en prisión preventiva. Creo que lo ha hablado y ha expresado muy bien y ha dado los datos mi colega Laure, no me extenderé en este punto. Otro es el tiempo que están en prisión preventiva. Hemos de pensar que en la Unión Europea no hay unos estándares mínimos de prisión preventiva, porque podemos encontrar estados miembros donde puedes estar 6 meses en prisión preventiva y otros como en el Estado español, y en mi caso, mi marido Raúl Romeva estuvo 2 años en prisión preventiva y en España puedes pedir una ampliación de 2 años más, por lo que podemos encontrar presos preventivos que pueden estar hasta 4 años en la prisión. sin un juicio. Por lo que esta temporalidad también la tenemos que tener muy en cuenta cuando hablamos de prisión preventiva. Y en tercer lugar, que se habla menos, es las condiciones en las que están en la cárcel los presos preventivos. En nuestro caso, mi marido ha estado en 3 cárceles diferentes en esta situación de prisión preventiva y tenían en común que los presos preventivos no están con el resto de los presos, están en módulos separados, no pueden tener un plan de tratamiento individualizado. Eso quiere decir que los presos preventivos no pueden acceder a la educación, a la escuela de la cárcel, a los talleres, a las instalaciones de la prisión, porque en realidad no son presos, no se les entiende como presos ordinarios, y esto provoca que están en un limbo, que están en un agujero negro dentro del sistema penitenciario que crea una deshumanización extrema. Déjemelo decir con esta dureza, ¿no? Están y que nadie puede volver ni nadie puede reparar las consecuencias de una prisión preventiva, ni para sus consecuencias, los lazos familiares, la situación de dejadez, la situación de inactividad que produce estar meses o años en esta situación, las relaciones con la comunidad. Nunca más se puede restablecer y no se pueden reparar estas consecuencias que a menudo, no siempre, pero a menudo, la sentencia es absolutoria o la sentencia es menor del tiempo que ya han pasado en prisión. Por lo que la situación es muy dura y tenemos que poner el foco también en qué condiciones están los presos preventivos en las cárceles europeas.
We've seen a bunch of digital solutions being brought forward during the crisis, in particular enabling people to attend their court hearings, such as pretrial detention hearings and review hearings, from prison via telephone or via video links, instead of attending court in person, obviously for sanitary reasons. But what we're seeing now is in different member states at a national level, but also at an EU level, we see a risk of this practice being normalized. And we would like to question, can you really present a defense from prison over a call to the court? Can you make your case for release and participate in your hearing as you will have a legal right to, and convince the judge that you can be trusted and released over a Zoom call? I mean, we're really worried that remote hearings will result in more and more people in pretrial detention. And that's why we think it's so important to keep talking about pretrial detention, even though it's been on the political agenda for years and we haven't seen yet an EU legislative initiative. We think that now it's more important than ever to keep talking about pretrial detention and make sure that its use is in line with human rights standards.
Como diputada y como eurodiputada ahora del Grupo Verdes ALDE, estoy dentro del Comité de Libertades Civiles y Justicia, y uno de los focos que quiero poner en esta legislatura es en el ámbito penitenciario. Evidentemente, mi trabajo va a ser poner en esta agenda política europea estos mínimos estándares de las prisiones, pero también el uso de la prisión preventiva y ver si podemos conseguir esta herramienta, esta directiva, para tener unos mínimos estándares en prisión preventiva, que sería una herramienta muy útil para poder trabajar en este sentido.
Why is pretrial detention an issue in terms of rule of law? First, it's because states, although they have legitimate powers and reasons to give law enforcement authorities legal powers to investigate and prosecute crime, and in some cases that may require detention, it doesn't mean that states have a blank check to do whatever they like and to act arbitrarily. They have to operate within the framework of the law. So it's fundamental for our criminal justice systems to be set up in a way that enables cases where law enforcement has exceeded their legal powers to be exposed, including where states have exercised their power to deprive someone of liberty. And it's very much, I think, where we need to start. When we talk about the rule of law, we need to start with police custody. We need to start with imprisonment, because this is where individuals are faced with the most powerful tool that a state has against each and every one of us. It's deprivation of liberty. And so the EU legal order, which prides itself and is based on the rule of law, needs to be characterized by legal certainty when it comes to these state powers. It needs to very much embody the prohibition of arbitrariness in the use and application of state powers. And this also means protecting our judiciary, making sure that they are independent and impartial, not only on paper, but also in how they operate, in how they are equipped in a way to provide us with effective judicial protection.
Claramente podríamos decir, en castellano decimos vasos comunicantes. La política no puede funcionar sin los estudios, la política no funciona sin la actividad civil, sin las asociaciones, sin el saber científico. Por lo tanto, estos estudios son muy importantes para realizar nuestra actividad política. Nuestra actividad política no se basa en nuestras sensaciones, sino en los estudios que nos llegan de los expertos, por lo que es muy, muy importante siempre estar en contacto una cámara como el Parlamento Europeo, como la Comisión, con los expertos, con las asociaciones, con los centros penitenciarios y con las asociaciones de jueces que al final son quien dictan, ¿no?, la cuestión tan importante como la prisión preventiva en este caso. Al final,
I think civil society has a very important role to inform policymakers, not only through research, but also through documenting human stories and making this whole discussion much more about the humanity that, as Diana has mentioned, is lost in prison. And especially in this context of digitalization agenda, where we're seeing pre-trial detentions, hearings increasingly happening remotely, and we're seeing a political will towards normalizing such practices, because it's perceived as being driven by efficiency, as something that will promote efficiency. But such efficiency-driven changes in underfunded and overstretched justice systems is just going to move us further towards justice systems that are effectively imprisonment machineries, where people are reduced to units that need to be processed, to an abstract type and a risk to be managed. And it's very, very important in this efficiency-driven agenda that we see that part of the discussion around modernizing justice systems, which is necessary, also factors in the need to reinstate humanity in this whole process and to focus much more on that key element that appears to be lost in the current discussions.
Thank you to Laure, thank you to Diana. Your insights are very valuable. It shows that the reasons behind the overuse of pretrial detention are manifold or complex, and that the ways of action are also very complex but very promising. Thank you for your time. You can find out more about this issue and about other ICPR research findings on prisoninsider.com website and on prisonstudies.org websites. Thank you to both of you. Goodbye.